Now, of course, not all the justices agreed. The same three justices that have dissented in so many other straightforward cases filed a dissent in this case. This time, Justice Kagan wrote the dissent, which Justices Sotomayor and Jackson joined. No one doubts that the distribution of sexually explicit speech to children of the sort involved here can cause great harm. Or to say the same thing in legal terms, no one doubts that states have a compelling interest in shielding children from speech of that kind. What is more, children have no constitutional right to view it. The Texas statute before us, HB 1181, addresses speech understood in First Amendment law as obscene for minors. That label means the First Amendment does not protect the speech for minors. The state can restrict their access without fear of colliding with the Constitution. So if there's no doubt that the distribution of sexually explicit content to children is harmful, that the states have a compelling interest to shield children from said content, and that the states can restrict minors' access to this content without fear of colliding with the Constitution, to what are these justices dissenting? The trouble comes in the last two sentences, italics. Speech that is obscene for minors is often not so for adults. For them, the category of obscene and therefore unprotected speech is narrower. So adults have a constitutional right to view the very same speech that a state may prohibit for children. And it's a fact of life and also of law that adults and children do not live in hermetically sealed boxes. In preventing children from gaining access to obscene for children speech, states sometimes take measures impeding adults from viewing it too, even though for adults it is constitutionally protected expression. What then do we do? Well, that seems to be the question, Ms. Kagan. What can we do? Cases raising that question have reached the court on no fewer than 4 prior occasions, and we have given the same answer, consistent with general free speech principles each and every time. Under those principles, we apply strict scrutiny, a highly rigorous but not fatal form of constitutional review to laws regulating protected speech based on its content. Okay, so Kagan and company want this case reviewed under strict scrutiny rather than intermediate. But if what she's saying is true, would HB 1181 not survive the narrowly tailored test of strict scrutiny? After all, the law simply requires these sites to require a reasonable age verification test in order to allow adults to access them. And laws like HB 1181 fit that description. They impede adults from viewing a class of speech protected for them, even though not for children, and defined by its content. So when we have confronted those laws, we have always asked the strict scrutiny question. Is the law the least restrictive means of achieving a compelling state interest? There is no reason to change course. Is Justice Kagan telling us that she would have overturned the Fifth Circuit's decision? After all, HB 1181 doesn't prohibit adults from accessing this content, only impedes them. But isn't it for a good reason? Does Justice Kagan believe there is a less restrictive means of achieving the state's compelling government interest? What would that possibly be? But what if Texas could do better? What if Texas could achieve its interests without so interfering with adults' constitutionally protected rights in viewing the speech HB 1181 covers? That is the ultimate question on which the court and I disagree. Again, what better ideas does Justice Kagan have? Perhaps she thinks the district court's idea would work better. In the district court's opinion, for example, encouraging parents to install content filtering software on their children's devices would be a less restrictive means of accomplishing the state's objective. Would this be less restrictive? Yes. But would it achieve the state's objective? No. Because anyone who has had children knows they are wizards at getting around rules. Let's assume you put content filtering software on a child's phone, if you put content filtering software. What is to keep them from removing it? Or simply using a friend's device, a public internet device, or any one of a dozen other methods, or simply finding a site that hasn't been added to the filtering software yet? Also, since the law already prohibits distributing of tobacco and alcohol to minors, and it is the responsibility of the distributor to ensure compliance, not the parents of the minor, why should obscene material be treated differently? HB 1181 impedes the exercise of that right. Recall how the statute works. To enter a covered website with all the protected speech just described, an individual must verify his age by using either a government-issued identification, like a driver's license, or transactional data associated with things like a job or mortgage. Again, these are the same requirements to purchase alcohol or tobacco. If it's considered such an incidental infringement on the rights of adults for these products, Why not obscenity? For the would-be consumer of sexually explicit material, that requirement is a deterrent. It imposes what our First Amendment decisions often call a chilling effect. Now, as Justice Kagan has already pointed out in her dissent, these products cause great harm to children. Perhaps this chilling effect is a good idea. After all, age verification for alcohol and tobacco has the same chilling effect. Would the dissenting justices dissent to that? All of that leads, under well-settled law, to just one conclusion. HB 1181 is subject to strict scrutiny. Except it's not well-settled law, but well-settled precedent. Even conceding Justice Kagan's belief, I think this law would survive strict scrutiny.